I'm going to introduce the speakers. It's a pleasure to, I've worked with every one of these presenters on webinars and on seminars, and this is, I can tell you they always bring their A game to these presentations, and so this is not going to be one where you want to multitask. Not that you would do that, but let me just go through them, and I'll give brief introductions. Oliver Brew is Vice President at Liberty International Underwriters Professional, Privacy and Technology Liability. He's a leading underwriter in this field. He's presented at numerous industry conferences, and including the Department of Homeland Security Cyber Risk Culture event early in 2013. David Katz is a partner with Nelson Mullins, Riley, and Scarborough in their Atlanta office. He leads the Privacy and Information Security Practice Group there. He counsels clients on the development, management, and oversight of privacy and compliance programs. John Kropf has, for over 15 years, been in the legal and policy practice. He has experience in privacy and information law in both government and corporate cultures. Most recently, he worked as the Deputy Counsel for Privacy and Information Governance for Reed Elsevier. That's the parent to LexisNexis. And he was previously member of the Senior Executive Service, serving as Deputy Chief Privacy Officer for the U.S. Department of Homeland Security's Privacy Office. Adam Miller has worked for the California Attorney General's Office in San Francisco since 1997. And he's the inaugural Supervising Deputy Attorney General for the Privacy Enforcement and Protection Unit that was created in 2012. So, gentlemen, thank you for participating in this event. It's a pleasure to work with you again. And with that, John, you're our first panelist. I'm going to turn it over to you.
Well, Tom, thank you very much for that kind introduction. First of all, I just want to say that to everybody on the call, I think it's extremely timely for all of you to be listening in and not only getting this as a CLE credit, but the topic itself, as you can't open a paper these days without having read about some sort of a data incident. So it really is quite timely to be listening about how to manage a data breach. And just a couple of weeks ago, there was a report released in the Economist Intelligence Unit Risk Report that said as many as 50% of CEOs do not know how to handle a major data breach. So again, just reinforcing the thought here that this is a very, very timely topic. So just keying off of our slides here, I'm really going to start with Roman numeral 1, which is the foundation, a comprehensive set of controls and procedures. And maybe one way to think of this, to break up the presentation a little bit so it's digestible, is think of this as the front end of the process. If you don't have a comprehensive privacy management program, or you do have one, you either need to build one or you need to strengthen what you have. Sooner or later, inevitably, your organization is going to experience some type of an incident, and having that comprehensive program built in place up front and ready to respond is where you want to be at this point in time. So really this is kind of the front end process. The rest of our panelists, I think I would venture to say that they're really going to give you kind of the after the fact what to do when something happens. So this is going to be what I would describe as a 30,000-foot view of kind of the ideal privacy management program that you'd like to have in place. It's the kind of thing that, think of it like if you want to stay healthy, you eat right, you exercise, you get checked out by your doctor before something happens. So when something does go wrong, you're in the best possible position health-wise to manage it. So this is to put you in the best possible position in your organization to respond to an incident. And I'm going to take really 10 basic elements that would make up kind of the ideal privacy management program and walk through them here. And then, of course, then the follow-on will get into certain aspects of these in greater detail. But to give you some perspective on where these 10 elements come from, there was a paper done by the Canadian Privacy Commissioner along with two provincial commissioners, the Alberta and British Columbia Privacy Commissioners. It was done last year, and it was called Getting Accountability Right with a Privacy Program. And these 10 elements are really adapted and inspired from that paper. And the benefit of that particular perspective from the Canadian Privacy Commissioner's office is it really has international scope, international appeal. The Canadian approach not only would cover many of the things that you would want to have here in the U.S., but internationally it's also respected and really gives you great coverage in the EU, Asia Pac, and elsewhere. So that's just something to keep in mind from an international perspective. So let's dive into the elements themselves. The first element is really, it may seem obvious, but it really can't emphasize enough, number one, that you need an organizational commitment to privacy. You need a commitment from the leadership of the organization. And that is really endorsing the mission of privacy, endorsing privacy as a value within the organization. And to do that, you want some mechanism that really ensures that the senior decision makers have endorsed the organization's commitment to a privacy program. And with that, some program commitment to resources proportional to the volume and the sensitivity of your data. So that's number one. Number two would be, once you have that commitment, is to take on a personal data inventory, and this is really kind of the big roadmap that would tell you exactly what kind of data you have, where it resides, how sensitive is the data. For example, are you holding large amounts of health data or financial data, other types of sensitive data, and who has custody and control over it. So these are, it's basic fact gathering, but it's something that you really need to do at the front end. So when you do need to respond quickly, you have that inventory. You know where to go and where to look and what you have. The last point on number two is the applicable law. You really need to know whether the data that you hold is covered by any number of federal laws, such as the Fair Credit Reporting Act, GLBA, HIPAA, COPPA. Those are just some examples, and of course state laws. And Adam is going to talk later on in the presentation about the particular applicability of state laws and the perspective of the regulators from the states. And then, of course, you may have, in this day and age, you may have data that is cross-border data or may be implicated by other sovereign jurisdictions in the EU or Asia Pac. So you also need to be mindful of that. So those are 1 and 2. Let's press on here. Going to the next slide, we have documenting data privacy policies. So you've done the commitment, you've got the inventory, and now you need to really make sure that you can provide the proper policies for your organization and have those documented. And that may be a group of policies such as your website privacy policy. Any organization that has a website needs to have a privacy policy. In addition to which, you may have some cross-border data. Do you need to have a safe harbor privacy policy? So all of those policies need to be then overlaid on top of the data that you have. And they need to be linked when appropriate to applicable law. So as I mentioned earlier, Perhaps you have data that's covered under GLBA or COPPA, just for example. So that's number 3. Number 4 is looking at risk assessment and mitigation. What that means is, this was actually, risk assessment is now a big topic. It's kind of a big buzzword in the privacy community. At last week's IAPP, there was a big panel now, a panel that was done on doing a risk-based approach on managing personal information, and this was really presented as a new proposal aimed at the European Union's new data regulation. So that's just to let you know that risk assessment it's a widely accepted practice of how to manage this data. And what number 4 really breaks out to be is, does the organization conduct a regular assessment and mitigation of the data that you hold? And those risk assessments really need to be proportional to the volume and the sensitivity of the data that you hold, and a regular basis could be on an annual basis, just some regular interval. Number 5, documented program to regularly train employees about policies, procedures, and roles. Well, if you have these policies in place, they really don't mean a whole lot unless your employees are familiar with them. And those types of trainings are based, really, they're tailored to the type of employee and their day-to-day duties. You may have, for example, a basic Privacy 101 type of course that would be required of all the employees just to be able to at least issue spot and know a privacy issue, a data protection issue when they see one. And then on top of that, you might have a more intensive, higher level course for those employees that have more day-to-day responsibility managing and safeguarding data. You know, it's the kind of thing that you need to document as well. In some cases, this could be helpful to you down the road if you do have to talk to a regulator, and again, perhaps Adam may touch on that. Let's go on to the next slide. We're now at number 6, and this is to build a breach incident management response plan, and that's something that David is going to talk about in depth, but it's really, in short, it's to build processes and assign responsibilities for dealing with the breaches, and this is something that will be cross-functional in nature. You're going to need to involve many parts of your organization, not just a general counsel, and a CIO or a CISO or external communication. You're really going to need to know who has responsibilities here and be able to have a plan ready to go when something happens. So that's 6. With number 7, we have to stop and think for a moment about external service provider management. There are risks associated with sharing your data with outside third parties, which is, of course, a necessary part of your business operations. And what that would mean is, are you going to look to your agreements? Are you going to bind your service providers to your privacy policies and your privacy standards? Are you going to require them to provide notification of a breach or an incident if something happens at their end? So that's something that you need to think about with number 7. So we've progressed now up to 8, which is external communication. This is really making individuals aware of your company or your organization's commitment with respect to how they process data about individuals, what are the policies and procedures involved, and at a basic level, how to contact the organization if there is an issue or an incident. You want to be contacted first. You want to be in the know before anybody else if something goes wrong. And if there's not an easy way to contact your organization. If you haven't assigned some dedicated line of communication, email, 800 number, whatever, you may not be the first to find out about your incident, and you want to be the first to find out if there's going to be an incident. So we're now in the final slide here for the comprehensive plan. We're up to number 9, which is oversight and review. This really is to develop a basic plan of how do you conduct the oversight of the data privacy or program that you're building. Do you have people that are assigned regular responsible roles in doing this? Is it your general counsel's office? Do you have a separate compliance office? You need to make sure that you have assigned responsibilities for reviewing and executing and implementing all of these policies and procedures that you're building. Many organizations will have some type of a regular counsel that meets on a regular basis to monitor that. And this number 9 also kind of bleeds into some degree into our final point, which is number 10, which is just to regularly assess and revise controls as needed. If you do have an incident, what are lessons learned from that incident? How can you revise and update your policies, the risk assessment tools that you use? Do you need to modify your training and education? All of the things that we have talked about above. So that's really at the 30,000-foot view what you want to build at the front end. So with that, I'm going to advance up to Roman 2, and I'm going to make our handoff to David Katz. So David, off to you.
Great, thanks. So I'm sorry to say that I do not see Lexis Breach Talk trending yet on Twitter, so hopefully throughout the remainder of the presentation we'll start to see more activity around that code. But thank you very much, Tom, and it's really an honor to be on the panel with the co-panelists, and having worked with them before and getting them to speak is as exciting for me as the opportunity to talk to all of you. So, and I wonder, John, if I may, just in the interest of concluding your presentation, ask a few follow-up questions, and I know Oliver may have one as well. John, for those folks that are kind of listening or out there that may be finding it difficult to sort of initiate a privacy program, what advice would you give to them, and where, how should they start, I guess, getting that executive buy-in within their organizations if it doesn't already exist?
Well, I think the sort of what you need to do is play the long game in terms of building relationships. If you don't have the resources, and I'd be kind of surprised by now if somebody is not thinking at the top of their organization about data protection and data privacy, it would be very surprising at this point. But getting the resources, that's the difficult question, and I think it just goes to building relationships with those key players in the organization, such as your chief information officer, your chief technology officer, your chief information security officer. And sometimes you may have to be in a position of trying to coordinate and even see if you can team up on resources at a basic level. But it doesn't hurt to make a collection of some of the stories that you read in the media about just what can happen. And I mean, Target is front and center an example. I hate to say it, it's a horror story that you can use it if you need to make that case that to get somebody's attention up in the leadership that this is what can happen. I mean, I think their stock price dropped and their sales dropped and so on. So that's the worst case scenario, and you hate to use that, but you need to be ready with some stories about how this is going to impact the organization's bottom line.
Great. Okay, I don't know if there are any other questions. If not, we'll go ahead.
If I, this is Oliver. I wonder if I could just make an observation, John, on some of your comments. I thought certainly the training element from an insurer's point of view, we see as a critical piece in terms of embedding the culture of privacy and ethics and security all being tied together in the way that an organization approaches privacy issues. And then on the external communications item, certainly when you have an incident, the crisis communications is critical, but also, as you mentioned, the ongoing communications plan. So if privacy issues come up with consumers and they want to change information or something is inaccurate, they have a vehicle to do that. So it's both sides of handling the crisis and also the ongoing regular communications with consumers to make that platform as open as possible.
That's an outstanding point, Oliver, and I think that just goes to show that you also need to involve your corporate communications or your external communications office, whoever might that be, to be part of the incident response plan.
Great. Okay, so the next portion of our presentation will focus on both reacting to a breach and then what are the steps that are necessary once a breach occurs. So you may find it interesting, I'm trying to advance here, the next slide, that the, sorry, one back. Keep going back. One more. One more back. Okay, so there we go. So the Chinese symbol for crisis is both a combination of the two symbols for danger and opportunity. And I think as we've seen with the ways that companies tend to handle breaches, is there are two ways that they're handled, good and bad. And the ones that handle them poorly, there's certainly an element of danger, and that's danger to the brand, danger to the board if there are tremendous loss associated with the breach. And the ones that handle them well, there's opportunity to reinforce the brand and to demonstrate that the company really takes ownership of the breach and following the breach puts in processes and procedures to make sure that nothing like this happens again, and you typically see that type of language communicated in notices. So, when something happens within your organization, I think, it's really helpful to sort of think about it in terms of what opportunities does this present for the company and how could this potentially be dangerous. And so, the idea that this is both including elements of each is something that to be considered when these events occur. And so at the very beginning, to underscore a lot of what John said, you have to have a plan because when these events occur, when these crisis events occur, it's very easy within the company for different constituencies to begin to want to take control of the situation. And unless there's something really written down that folks can turn to say, what do we do next, there's a real danger that things could quickly begin to become unraveled. And part of that plan is having a team in place to quickly gather the facts and certainly at the very outset begin to stop whatever bleeding there might be by way of data loss and to quickly determine if the breach has actually been stopped. And once that's been determined, how the breach occurred, because until those pieces are really carefully and clearly understood, it's going to be difficult to do sort of any analysis on what the notification obligations might be. And with respect to that investigation, there needs to be very good communication among all of the constituencies that are involved. So depending on how the breach originated and the investigation, there'll need to be a lot of coordination internally between the groups that are responsible for gathering those facts. And it may be that outside experts are part of this group. If it's something that was generated as a result of a hacking attempt or a failure of an information security process, it may be required to bring in somebody that has those specific expertise and that can engage with a company's IT department and really someone with the technical capabilities to really determine what occurred. And again, as part of that investigation, it's important to determine, where are we looking? What is the scope of this? What's the scope of the investigation? But then what's the scope of the breach? How many of our systems have been impacted? Are there other locations within our company that are affected? And to really start to, understand what the company is dealing with in terms of scope. And then finally, making sure that each part of this process, the attorney-client privilege can potentially attach. And this is a very broad topic in terms of how this privilege attaches within an investigation and how much of the investigation will actually come under the privilege. But the main point is that once counsel's hired and information is intended to be confidential and secured for the purposes of legal advice, there's at least an argument that facts that are being gathered could potentially be subject to the privilege. But these are things that you want to have thought through very carefully before there's a breach. Who will be the main point of contact? Who will be conducting the investigation? Who will have oversight for the investigation? Will a report be written? Will a report be generated and sent to the upper levels of management, to the audit committee, or to the board of directors? And how will the privilege be protected? So the time that's spent sort of developing that piece of the program is worth its weight in gold once a regulatory or class action becomes a possibility. So underscoring that is, these events also require immediate consideration of how they will be communicated and what to communicate. And typically where you see companies get in trouble is where they have not really clearly thought out sort of what the message is and to communicate to consumers and to the media. And where companies have had issues is where they've either not been clear, where they've communicated without knowing all the facts, or where they've been forced to come back and correct something that wasn't correct. And you've seen that recently in terms of some of the more larger data breaches, that they tend to take on a life of their own once they become public. And to the extent that there's the ability to spend some time really thinking through how would we communicate this? Do we have resources internally to communicate this? Do we need to hire experts to communicate what's occurred within the business? Are all things that can be done sort of without the pressure of the immediate response in advance. And finally, maybe this goes without saying, but really, each time you communicate and every piece of paper that you're generating as a result of this is potentially a record that could be used against you or to your benefit. So it's really important through the course of this breach response that you consider exactly what you're putting out and what you're communicating. Next slide, please. So really there are two types of risk management, and some of this goes back to how quickly and how well you can influence within your own organization the culture of privacy and good information security. And that gets to just proactive risk management. And that's easy, right? It's controlled. It's a world of budgets. It's a world of planning. And the place where you don't want to be is reactive risk management. That's certainly harder to control. It's difficult. It's expensive. And the underlying tone with reactive risk management is really to get me out of trouble no matter what it costs me. And that's sort of been the approach that I think most companies have taken with respect to risk management on the data breach side. And that should make Oliver very nervous. But I think that's been the environment that we've been in. And my sense is the market is, at least in some instances, really starting to decide that this may be an area to spend dollars in proactively. Go ahead, next slide. So the first element is really, review your plan. If you have a breach response plan, you need to, kind of take a look at it, update it, and be thinking about what are some things that you need to adopt or change. And if you don't have a plan, it's one to develop pretty quickly. And you should also be considering conducting a risk assessment within a reasonable period of time and with outside counsel potentially to protect the privilege. And that's really important. Until you have a really good and firm handle on the data environment, it's going to be difficult to understand where your weaknesses might be. And so to the extent that that can be done proactively with potentially members of a response team that would be handling a breach, that could also be very valuable when bad things happen. Next slide, please. One back. Apologize for the delay here. Okay, so very important. You know, sometimes these events take on almost like a fog of war kind of environment, right? There are things that are happening very quickly, and you really want to make sure that there's at least one person in the organization that's going to have control and can be the individual that is sort of manning the response. Because when these situations are occurring, they're going to have to be decisions, and they're going to have to be informed decisions to be made very quickly to protect the company in addition to customers. And if that person hasn't been identified, and depending on your corporate culture, it may be difficult to make a decision. It may be an environment that's very outside of the corporate comfort zone, and it won't be a collaborative environment. It'll be an environment where someone will be making decisions that could have a very large impact, could be reflected in the media, and could really affect the brand for many, many years to come. And you know, maybe that's a team, maybe it's one person, but it has to be, there has to be a commitment among that core group that they will make decisions. And you know, there can certainly be conflicts within a company about what's in the best interest of the company or how things get communicated. And typically what you see is internally there's certainly a group, and usually it's the marketing department, that has a very clear idea of continuing to protect the brand through an event like this. And oftentimes you see a lot of sort of real careful review of notifications and trying to soften language or to change language. And really the important thing is you know, how you reestablish trust with that consumer and the protection of the brand and comply with your obligations under law. So someone within the organization is going to have to be prepared to call those balls and strikes and say, no, we have to go this way, and make the decision about what's in the best interest of the company. So next slide, please.
David, just keep things moving, and we'll make sure these slides are synced up.
Okay, yep. So you want to make sure that you're also prepared to explain what you did and why you did it. And you know, there are going to be questions related to any event, and there's going to be potentially legal and regulatory fallout. And that's why it's very important at the beginning that you're working with your outside counsel and your internal counsel to make sure that you can explain the decision-making process, why you notified when you did, how long did it take you, what were you doing in the interim period before notification went out, and that you're constantly aware that you're hypersensitive really to the record that's being made at each point along this event, because you always want to be in a position to go back and say, you know, to your customer or to a regulator, that we did everything that we could that was within our power to respond appropriately, to respond quickly, and to begin to mitigate any risk to the consumer. And you know, if you can be consistent from start to finish with that as an underlying philosophy, and you're fortunate, you should be able to make a good record and be able to stand behind the work that was done relative to the response. So you have to be prepared, as the slide says, to explain your actions, and you are going to be required at some point to communicate with your customers, investors, or the media. And so it's really critical that that's given very, very careful thought during the course of the response, and that someone has the designated responsibility to begin to communicate. And what you typically see in these situations is a call center is set up to a third party or internally, and there's a script for that portion of the response. But really there needs to be an internal script within the company to be able to communicate with employees, to be able to communicate with your business partners, and even maybe potentially customers that have not been affected by the breach, and people that you may want to proactively reach out to once the breach becomes public to give them assurances of the response. And I had an example of in one instance where consumers as part of another business weren't affected, other business partners weren't affected, and the owners elected to go ahead and call them proactively and tell them what was occurring rather than sort of have them see it back in the media or pick up on it as part of a story. And that sort of diligence and that that ownership and that responsibility, I think, can be tremendously impactful in these situations by reestablishing trust with your customers. So also part of this is being prepared to communicate with regulators. That's our next slide. Once there's a regulatory inquiry made, once you receive those documents from a state AG or the Federal Trade Commission, you're really on the record, and everything that you've done up until that point addressing this is something that could be examined and scrutinized later. So really important that you consider that as you're working through the breaches. The other thing is you want to, if you have a plan, you want to practice your plan. And that may seem silly. I mean, people at work are busy. They don't have time to engage in hypothetical scenarios in a conference room. Folks have a lot going on in their schedules. But to go through that exercise can be tremendously revealing. And you really want to avoid, day one of the crisis as being the time where team members are meeting each other. So, to the extent that it's a 30-minute session, maybe in the morning, and you bring donuts. Everybody tends to like donuts. You want to train your employees to execute the plan, and if nothing else, you want to get them familiar with it and get that team together and run through, what would we do? It's tremendously, I think, important and can give you a real advantage. Finally, on the crisis management piece, you really shouldn't waste any time reviewing plans or drafting plans and engaging your team. And just, with respect to budgets, budgets are important and planning is important. But if you delay, creating this plan, or you reprioritize it with respect to something else, that could be a very expensive mistake in the long run. And, understanding that plan and having the ability to execute it could really save you time and a lot of money, value, and brand equity. So it's important to have a plan and practice it. So we're going to go through now, just at a very high level, some of the notification obligations and some of the things to think about once the breach has occurred. And there are 46 states plus the District of Columbia, Puerto Rico, Guam, and the U.S. Virgin Islands that have data notification statutes for breach of sensitive information. And part of the challenge, obviously, is when a breach occurs, making sure that you can identify all of the areas in which you have obligations and responsibilities. So as part of the data breach statutes, there's some pretty consistent pieces that go into those statutes with respect to the data elements that you should be considering and investigating whether or not we're exposed. And those are typically your first and last name of the customer plus one or more of the following. It's Social Security, driver's license number, account number, credit card number, debit card number, usually a debit card number or account number combined with an access code or PIN to access the account. And that is typically computerized data and personal information. but most statutes have exceptions for publicly available information that's lawfully made available through federal, state, and local government records. But the point is that the exercise really does require, and I'll show you a slide in a minute with the various breakdown of the statistics, but the exercise really does require going through each of the statutes and making sure that you're in compliance with the laws and the notification portions of those statutes. And just for 1 second, a discussion about the notification formats. Typically what you see after the letter has been drafted, where the company explains why you're receiving the notification, what the facts are surrounding the breach, why the company is choosing to notify you, and what steps you can take. What you typically see is a breakdown of the specific state information in those notifications, so that the company can send out one notification. And what you normally see is a reference guide that has all of the information that's state-specific, that gives you the addresses and contact information for credit monitoring, companies Experian, Equifax, and TransUnion, and then some state-specific language on security freezes. And Iowa, for example, requires you to report identity theft to law enforcement and the Attorney General. Oregon has a specific requirement that you report identity theft to law enforcement of the Federal Trade Commission. And then Illinois and Maryland and North Carolina have some specific information about, asking or making sure the consumer is aware of the various resources available to report identity theft. So, the notification format becomes extremely important with respect to regulators and how they view the sufficiency of the notification. And as we said before, the last thing you want is to have to re-notify or to have this come up again in the media because there was a failure to take some of the appropriate steps. So on the timing piece, there are different requirements by different states, and it's really important that as you are doing the analysis that you're paying very close attention to the states that have specific time frames. Florida is an example, no later than 45 days. Ohio also has a 45-day time frame following the discovery or notification of the breach. Vermont is another example. Wisconsin. So you have to be very diligent in terms of going through these statutes to make sure you've appropriately gauged the time frame. So here's a slide that's been up for a few minutes that everyone probably has had a chance to read as I'm talking, but it really, I think, underscores in a nice way the different analysis that needs to occur with respect to the state data breach statutes and why you really need somebody who is familiar with those and has expertise to kind of walk you through the analysis. And really, it's hopefully that in the first 24 to 48 hours that analysis can be done so you can notify quickly. Other notification obligations, we've talked a little bit about the necessity to notify the board, the audit committee, the board of directors, sort of the highest levels of the governance function, whether formal or informal, of the organization to which you belong. And that's important because as we've seen through some other breaches, if there is an instance where there is value to the company that has been reduced, that could very easily fall back on the directors and those with fiduciary responsibilities or obligations. And you've already seen in the media where in some larger breaches, very quickly, fingers begin to be pointed, and there are pointed questions asked about what was known about the state of risk and what was done about it, and that goes directly to making sure that the senior members of management and the folks with oversight authority are aware of the risk, and then once the breach happens, are involved in the response. Certainly communication, as we've talked about, is important with your customers, your clients, regulators, and your carrier, insurance carrier. And also your business partners. I mean, there may be provisions and agreements that you're maintaining that require you to notify business partners and just generally create obligations for you if a breach has occurred. So on internal communications, really communicating with one voice, making sure that everybody within the organization is on the same page and communicating the same content to the various folks that may have a need to hear it or want to know about it. Making sure that depending on the severity and the likelihood of litigation or the reasonable anticipation of litigation, that document hold notices are being sent out. There could be a number of people that will want evidence both before and after a breach scenario. So it's important that as you're going through your response, you're also thinking from a litigation perspective. And oftentimes, what we find is it's very important to be, as we've talked about making the record, being mindful of the litigation potential of these breaches. So just to start to wrap up here, there's some do's here, and that's do identify and empower a response team, spend time thinking about the privilege, investigate and preserve the evidence, stop the bleeding, prevent further exposure of data, make sure you have a good communications plan, get your carrier notified and on board and start to communicate with those individuals, look at your notification obligations, involve technology and forensic experts as needed. And that concludes my portion, and I will turn it over to you, Ali. Ali, you with us?
Sorry, yes, I am. David, thanks very much for that. You talked about attorney-client privilege when you were referencing both the preparation of documentation for the actual risk management, risk assessment piece, as well as the post-breach handling. I'd love to, could you talk us through why it's so important to have the attorney-client privilege for the risk assessment as well as the post-breach scenario?
Sure. I mean, what the attorney-client privilege is designed to protect is the legal advice, the communication of the legal advice that the company has sought and intends to make confidential. So although you are investigating and probably pulling up facts that may be harmful that you may not otherwise be able to protect, what you want to be able to protect is the advice that's given, the legal advice that's given with respect to either how to remediate, how to respond, and what steps need to be taken. So it's important to make that distinction. I mean, the attorney-client privilege is not going to protect, in all instances, the facts that are generated. What it will protect are the communications that are made relative to those facts that are specific to the legal advice. And there are a lot of reasons why you might want to protect that. Certainly, if this is being driven by the board or some senior governance piece within the organization, you want to be able to freely communicate how to respond to what's been found and give it the attention that it deserves.
That's great. Thanks so much, David.
Sure.
So I'm going to take up the reins here and move on to talking about insurance for privacy and cyber risks. And you'll notice that I referenced both privacy and cyber in the title. And privacy is a familiar concept that's been around for as long as the Constitution and before that. Cyber is a slightly amorphous term that is, I think, somewhat unhelpful, but often is referred to some of the new media risks, and including things like viruses and denial of service attacks, and now also relating to a lot of the resiliency and the challenges that companies have in this interconnected economy where all companies are reliant on third parties to some degree, and obviously internet uptime as a critical part of their success to being an ongoing concern. So I'm just going to move along to the first slide. I thought I'd start with a cartoon. Credit to the New Yorker for this one. If you see this guy at your local state fair, probably not a competition you want to enter, with weight, height, date of birth, email, and social security numbers on his list. So just a friendly warning to start with.
You fell for that, didn't you, Wally? I think you did.
I did. So I just wanted to put this in context from an insurance perspective. No disrespect to anyone in the insurance industry out there, but insurance is not known as a particularly dynamic industry, and it's been around for centuries. And all of a sudden, these new risks have emerged in the last 10, 20 years as to how we've been able to handle them from a risk perspective. I'd just like to take you back very briefly. 15, 20 years ago, when the web was in its infancy, there were precisely 0 smartphones around, and the cost of storage 15 years ago was $60 per gigabyte. Today, that number is 5 cents per gigabyte. That's plummeted 1,200 times. And so as a result, with computers in every pocket and data everywhere all the time, the explosive nature of the risk landscape has dramatically impacted the way that all companies handle, store, process data. And not just personal information, but also, of course, corporate data as well. So the challenge we have is that many of the standard lines of insurance, particularly on the admitted forms and in the ISO market, have not kept up with these changes. And it's not that surprising. But they do not affirmatively cover these types of privacy risks. And I referenced some exceptions here. Many of you are familiar with the general liability form and some type of advertising or personal injury coverage. And there have been cases recently where the insurers have affirmatively taken action against their own clients to affirm their position that data does not constitute tangible property, and have won. So as a result of that position, it is widely recognized that a standard commercial liability policy is not the intended vehicle for many of these new media type risks. There are other types of insurance that may have some overlap. I mentioned a couple here, kidnap and ransom with its extortion element, and we have seen cases in the media of cyber extortion. And also crime coverage could include digital theft if that has some value associated with it. You look at, for example, at the intersection of the financial services industry and the financial exchanges in the use of an explosion of Bitcoin as a digital currency. That, I think, represents some of the dilemmas that we as an industry face. One other area that I think it was David that touched on in terms of the obligations of corporations relating to these types of exposures are the directors and officers. And we've already seen, not just in Target, but other cases where a data breach has led to some type of derivative shareholder action and thus exposing any potential D&O coverage as well. But having said that, these types of coverage are not designed and certainly not underwritten to address the specific risks of these exposures. So moving on to the next slide, the main heads of coverage for this type of insurance really fall into two major categories. The first is first-party coverage, and here I reference all of these types of costs and expenses that any organization may incur themselves in addressing the data breach exposures. So in all of the crisis handling that David referred to in terms of notification costs, that could include everything from where do you start identifying which customers were impacted, so extensive forensic analysis may be required, address verification, so you're sending letters to the right people, call center setup and preparation, as well as, of course, the legal advisory services along the way. In the aftermath of that, there could well be an extended crisis management requirement and even business interruption in the event of some type of network downtime if the event impacts in such a way. The second major bucket is the third-party coverage. This includes liability arising out of a breach, and this could include unauthorized access, not just a theft of data, but simply access, as I was referenced in one of the earlier slides, that access could be sufficient to warrant liability. And of course, as has already been referenced, the regulators that could expose liability to handling investigations from a regulator as well as a third party, which could of course include class actions from consumers, but also business partners and even clients, of course. Network security liability typically refers to the specific security threats relating to viruses or the liability arising out of being a conduit. So when denial of service attacks occur, they are often passed through multiple organizations to increase the impact of them. And there has been some cases where liability is attempted to be attached to those entities. And media liability. That means the intellectual property associated typically with internet-based risks, such as, of course, domain names, images, logos, and so on, but it can extend to the whole entity as well. So when we're looking at the underwriting factors for a risk, of course, there's a whole range of issues that impact how an insurer may perceive a risk, starting with their own understanding of their exposure and risk appetite as a carrier. And the list you see on the screen is certainly not an exhaustive one. The first consideration is the industry, and of course we've already touched on some of the industries which are more highly regulated and therefore have a higher severity impact in the event of a breach, such as healthcare or retail services. Compare that with some of the industries which have very limited personal information, such as perhaps logistics or mining or something like that. The size of the organization, of course, has an impact in terms of how likely they are to be attacked and the universe of data at risk, and the volume of data themselves. There are many organizations, particularly out of Silicon Valley and elsewhere, with very small revenue base, but extremely large data volumes. Think of Twitter and their recent IPO and how many hundreds of millions of followers they have. The type of data, of course, is important as well. So are they collecting credit cards? Are they collecting protected health information, social security numbers, and so on? All of these factors go into the assessment of the maximum type of exposure at stake. Now, risk management is a very broad topic, and I put three very broad buckets of exposure here that we consider: people, process, and technology. And they've all been touched on quite rightly. John was referencing some of the process issues in terms of having a plan and practicing that plan and having the training in place so that people understand the cultural issues and the sensitivity of handling such data. And the technology, of course, as well. Not just firewalls, but you may have seen on the earlier slide David presented that in 42 states there is a safe harbor for encryption. That's of huge significance to us as an insurance industry. If our client is using encryption effectively in all the critical stages where the data is residing, that could have a big impact on reducing the exposure. Incident response we've touched on, and I won't go into more detail other than to say not just having one, but having a robust incident response plan is critical. And then in terms of the history of the individual organization, like any insurance, we look at the claims history and the experience and any learnings that may have come from those claims. Moving on to the next slide, the application process. We start just like any other insurance where the broker would be engaged and would work with the client to review and assess the risk, perhaps using a gap analysis to identify areas where existing insurance coverage does not already apply. And the broker then working with the client would look to understand both the risks that they're facing and also which stakeholders are the critical ones in bringing that together. The application itself, depending on the size and type of organization, may be as simple as 1 or 2 pages or as complex as 10 or 20 pages. But ultimately, again, like every insurance and as a contract of good faith, we're reliant on the client to provide that information, which is then represented as being material to our assessment of the risk. Obtaining quotations is, in some ways, the easy part. That is where the broker is obviously going out to market, and the good news from the client perspective is that the number of markets in this space has increased significantly, and there are many more insurers queuing up to get involved in data breach and cyber risk. The challenge is, of course, that they're not all chasing the same business, and so that's where the reliance on the broker to bring together the right market for the right risk is really critical. Of course, given the infancy of the market, one of the challenges is that no two insurance policies look alike. Every policy has its own quirks and its own definitions and ordering and sublimits, and it's a complex area of exposure. That means that the most appropriate coverage for one client may not be appropriate for a company very similar, even with a similar appetite for taking on risks themselves. Selecting the most important coverages is really critical. Of course, finalizing the terms and any specific coverage is important, and not just the actual policy, but also more and more there are other factors that come into play, such as how claims are handled, which relationships an insurer may have in terms of the service providers I touched on earlier, such as forensics and legal services, and the ongoing risk management. More and more companies are looking to insurers not just as the writer of a check in the event of a loss, but as a source of support and expertise in terms of handling ongoing risk management. And finally, the coverage can be bound, and hopefully it won't just be put away in a drawer until the renewal. Data breach management and privacy risk management, like many ethics issues, is an ongoing process and is one that needs to be revisited certainly more than once a year. Moving on to the next slide, for larger and more complex risks, we do look at a variety of technical tools, sometimes as simple as a conference call to discuss a risk in more detail with the appropriate stakeholders. John referenced the type of people that may be involved in that. It could be everyone from HR to marketing, legal, IT, of course, finance, and others as well, in bringing those people together and really getting a good understanding of the exposures. We also look at technical assessments as well. So penetration tests may be familiar to some people. These are essentially ethical hacking, where with authorization, we will have a specialist attempt to gain network access into a client and see what vulnerabilities appear from the results of that test. The other major area, which is something Adam will talk more about, is the industry compliance standards. They, not just at the state level, but within each industry, certainly things like healthcare and retail with PCI. Numerous benchmarks are coming out as what are becoming the floor for the minimum expectations of privacy and security compliance. And remember, the challenge that has been demonstrated time and again in many of these significant breaches is that compliance is not the same as security. Security still has to be addressed in a proactive manner, and just because an entity is compliant does not automatically mean that they are entirely secure, of course. And finally, the ongoing risk management services I touched on, these come in a whole variety of shapes and sizes, but the emphasis is that they allow an ongoing resource and a valuable directory of services which any entity can come back to and help with their ongoing risk management when it comes to privacy issues. So here's a couple of areas that I felt were worth highlighting in terms of coverage issues. we talked about a data breach incident. Well, the challenge from an ethics point of view is when should an insured client notify the insurer? Is it at the point of suspicion because there is some type of anomalous activity on a network? Is it at the point of when it's recognized personal information has actually been exfiltrated and taken out of that organization? Or is it when the regulator comes knocking on your door? I would suggest it was the first of those scenarios, and the earlier, where insurance is involved, the earlier the insurer is engaged, typically the better the outcome in terms of support and proactive attempts to help minimize the risks, but also the ongoing advice, working in conjunction with the legal advisory services and, where appropriate, other technical specialists such as forensic services. Deliberate and malicious acts is a challenging area because typically insurers are not inclined to insure intentional or malicious acts. The challenge, of course, is, as we know, that a major part of the threat relating to data breach is by what is known as rogue insiders. And these rogue employees have, in time and again, been one of the sources of many of these data breaches. So some insurers are now looking to actively provide coverage for the malicious acts of employees, although not, of course, for board members, where the onus is clearly on their honesty and integrity to maintain the insurance contract. The final area is contract indemnification, and I think it was touched on briefly earlier, but this is a major issue where in the event you are a service provider working with major clients, those clients may have standards or expectations that in the event you are handling data on their behalf, they will be indemnified by you in the event of some kind of breach, which you are responsible for. The challenge, of course, is whether your insurance matches up to those contractual liabilities. And in the event it does not, what does that mean? And there could be a gap between the insurance and your obligations under contract. So my final thoughts are that in terms of how to succeed in responding to data breaches, the first is don't panic. Ideally, you have a plan, but even if you don't, that is not a productive use of resources. And inevitably, there are tensions and there are moments of stress when senior management are demanding a quick fix, and the requirements on the ground are for a fastidious and measured approach to understand exactly the cause of the breach and whether or not it's required to notify, and if so, to whom and how many people. Time and again, I've seen incidents where an initial assessment of a system vulnerability reveals a very high number of people impacted, but on closer scrutiny and after forensic analysis, it's identified that actually the malware or the hackers were only able to access a very small subset of that population, and therefore a huge amount of savings can be made as a result of taking a careful and methodical approach. In terms of the interaction with the insurers, it's critical that there's an open dialogue. Ultimately, every insurer, I think I can speak on behalf of, every insurer is looking to stay on the same side of the fence as their client and align our interests with our client's interests in looking at for a effective, rapid, and minimally costly mitigation and final resolution. Protect and preserve evidence. I think, again, from an ethics perspective, this is a critical piece, and where there are missteps, and for example, forensic analysis has been eradicated, or machines which have been compromised have then been deleted or scratched, that's really impacted the ability to defend against the lawsuits that come down the pipe. And finally, be proactive. I'm sure Adam will talk more about this, but the being proactive with regulators where appropriate can really help get in front of an issue. And I would urge that that is the case not only in the data breach environment, but outside of that crisis scenario as well. and particularly in those areas of more contentious industries, such as some of the social media and data broking and those types of services, where you can be proactive with regulators to reinforce the ethics and the privacy and security considerations. That will put you in a much better position in the event of some type of incident down the road. And with that, I will pass over to Adam, unless either David or John have any questions.
Yeah, I have a question, Oliver. What are you seeing with companies that, I mean, are you finding that companies are starting to have conversations with their brokers about cybersecurity? Are they in the right coverages now, or are they starting to re-examine that? I mean, what's your sense of the current market about coverages that have been written and are currently existing?
In terms of the current cyber coverages that are available, it is a fast-evolving market, and I would say every year there is a new version of policy forms from the major insurers, simply keeping up with the terminology. The most recent trend, of course, is to do with cloud computing, but BYOD, bring your own device, has been a huge issue as well, and sometimes is not specifically addressed in some of these policies. So we have seen a regular revisitation of existing policy terms, and let's not forget, there are still only a minority of companies that buy this type of insurance, despite all the headlines. So many companies are still coming to the table for the first time, and when they are, they're in a much better position because the broking community tends to be now much better educated and is taking a lot more proactive approach.
Great.
Adam, I'll hand the reins over to you.
Thanks, Ollie, and thanks, Tom, for your introduction, and thanks to John, David, and Ollie for the wonderful remarks that they've provided on data inventory, breach reaction, and cyber insurance. Before I get started, I have to give the usual disclaimer, which is that the remarks that I'm giving here today are my own opinions and do not necessarily reflect that of my office or the California Attorney General. Also, I know that David just talked about some state breach laws and all the 47, 49, I guess, jurisdictions. Obviously, I work for the California Attorney General, and so my focus is on the California breach statute, which, as probably you all know, was the granddaddy of all these data breach laws. You're welcome. We started this with our law in 2003, and it's resulted in many laws across the country, which are generally similar to California, and there are some differences, but I'm just going to focus on California law. And what I thought I'd talk about is, in general, what our data breach laws talk about. These are found in our Civil Code Title 1.81, which is entitled Customer Records. And although we're focusing in this presentation on cyber data breaches, it's important to know that data breaches come in all shapes and forms, and obviously cyber is more prominent right now, but we do have laws that talk about breaches and access to customer records. For instance, Civil Code Section 1798.81 requires a business to take all reasonable steps to dispose of customer records after they're done with it, such as by shredding or erasing. That is intended to cover type of situations where somebody dumps customer records in a dumpster, across the street, which we've had cases in this office, and I know other offices have done that as well. Then California has a general, what I call safeguards law, which is 1798.81.5 of the Civil Code, which says that a business that owns or licenses personal information about a California resident shall implement and maintain reasonable security procedures and practices appropriate to the nature of the information to protect the personal information from unauthorized access, destruction, use, modification, or disclosure. And this has already been talked about a little bit, what steps you should take to assess your security. The main statute I think that we're talking about today is the data breach notification statute, and that is 1798.82. And subdivision A provides that a person or business that conducts business in California that owns or licenses computerized data that includes personal information shall disclose any breach of the security of the system following discovery or notification of the breach in the security of the data to any resident of California whose unencrypted personal information was or is reasonably believed to have been acquired by an unauthorized person. So this statute focuses on computerized, and there was actually a question that was posted that I'll ask now, I'll answer now, which was asking about, and I think Ollie might have mentioned the safe harbor encryption exception. That's where this comes from, that if your data is unencrypted, then this data breach notification and by extension other states that have similar language doesn't apply. So what does the regulator such as California want from companies when there is a data breach? We want you to notify consumers and regulators as early as possible. Most expedient time possible is in our statute. Other states have other language. Some of them copy this, I think, and some of them have specific time frames. We don't. We just want you to do it as quickly as possible. We understand there might be law enforcement needs, and that is accounted for in the statute. And we also understand that sometimes, especially when you're talking about how cheap data is and how big hard drives and tapes are these days, it may take a while to assess the data, to ameliorate the intrusion, to figure out what happened. But we are really interested in protecting consumers. The problem with these data breaches is once they happen, there is risk of harm, real harm to consumers. And so our primary concern is that consumers know as soon as possible so they can be prepared. And although this is not in the statute, in our statute, we think the idea of rolling notices to consumers as soon as they're identified is a very good idea. I saw a comment also that was made in the questions about, well, you don't want to do it too soon because I've had problems where you notify too soon, and that's definitely a concern. However, we think that once you have an idea and are able to identify at least some of your customers whose data has been accessed, even if you haven't completed all your forensics analysis, you should start telling people as soon as you know. And in fact, we just had a case a month ago that we filed against Kaiser, and that was a situation, not a kind of a high-tech cyber breach, but where a USB thumb drive was found at a thrift store in Santa Cruz with over 30,000 records of Kaiser employees, including Social Security numbers, some minor information. We basically felt that there was a problem because Kaiser, they had policies in place. They did due diligence in assessing the data. We felt it took them too long to notify consumers. And one of the terms we put in the stipulated final judgment was that they had to start notifying consumers if this happened again as soon as they were able to identify them. We also think that you should consider substitute, a combination of substitute plus direct consumer notice. There are provisions in our statute, I'm not going to go into all the details because we don't have time here, that if you know who your customers are whose data has been breached, you should notify them directly. If the cost of that is too high or the number is too high, I believe if it's more than 250,000 or if the number of consumers exceeds 500,000, you can do substitute notice such as email or posting or press. And you might want to consider a combination of that. Remember, these are your consumers as well, and as someone on the call mentioned about one of the companies that's been a subject, a target of a breach, it's had real repercussions on the bottom line. That's because consumers don't like to have their personal information impacted. Another thing you might want to consider is proactively contacting a local or a headquarter attorney general office. So for instance, if you operate primarily in California, and even before you've identified who the people are, you might want to give me a call or an email. And I think my email is at the end of this presentation. It's good to have a heads up. And obviously, as in consideration, this has already been repeated, but I'll repeat it again. You need to protect and preserve evidence once the breach occurs. Obviously, there are attorney-client concerns about reports or communications that might happen, but that's an important ethical consideration.
Okay,
so
Adam. Oh, I'm sorry. You go ahead.
Yeah, I'm going ahead. I assume someone else is driving, but I can try to.
Yep, I got it.
Go ahead. Okay. So how do regulators assist with breach responses? So California, when this Privacy Enforcement and Protection Unit was formed in 2012, we were able to kind of fold in some of the work product of the Office of Privacy Protection, including Joan McNabb, who's our Director of Education, Policy, and Outreach. And so we were able to use and incorporate some of the practice guides that Joan had already done. In addition, just last month, we published a guide, Cybersecurity in the Golden State, how California businesses can protect against and respond to malware, data breaches, and other cyber incidents. And I recommend that you go to that link that I have there or the oag.ca.gov privacy page, and there's some good links not only for businesses but also for consumers. We understand that companies are often the victim of the data breach, that they might have done all of the planning that's been described, they've done the insurance route, they've assessed their situation, they've done tabletop exercises, yet they're still the victim. Data breaches, technical and physical intrusions still occur, but we are more concerned with the consumer victims. And I don't think it's acceptable for a company just to say, well, breach is inevitable, so we're just not going to prepare. We think that companies must anticipate in our cybersecurity best practice guide that's mentioned above. It actually says as one of the points that you should assume you are a target. So you have to take steps, and you must do what you can to prevent and anticipate potential breach. So this next slide, the first line is actually a quote that I found in a LexisNexis article written after a cyber insurance conference that I went to last year, and I thought this was a good general summary of what attorneys general, it's a common typo, look for. So does the company have policies in place? Have they thought about this? Has all the steps that David and John were talking about before, and insurance also as a possible assessment, has that happened? Have they done their due diligence? Are they keeping consumers and regulators updated? Are the breach notices in plain language? That's actually a specific requirement of our statute. Is the focus of the company on assessment, repair, protection of the consumer's PII, or are they more trying to defend their business plan? There's been some discussion about attorney-client privilege, and we certainly recognize that can occur, but it's also important to note that just because you have an attorney, an in-house attorney in a room when you're talking about breaches or pre-breach analysis, or just because an attorney is CC'd, an internal attorney on a email list, that doesn't automatically mean that the attorney-client privilege attaches. It has to be that the communication is for the purpose of obtaining legal advice. So I think if there's too much reliance on attorney-client privilege to try to hide documents and a discussion of what analysis has happened before and after the breach, I think that's going to be an issue for us. We don't have the resources to investigate and prosecute every breach that's out there. We're going to look to the larger breaches, the more significant breaches, and if we get the information we need that answers our question in a timely fashion, we'll probably just move on. Oops. Other questions that we are going to want to know: who's in charge of privacy? This kind of dovetails into the prior discussion about that you shouldn't wait until the breach to figure out what to do. And it's important for us to know, who is in charge to know these decisions. Was someone consulted? Not necessarily an outside counsel, not even necessarily a chief privacy officer, but someone within the enterprise that has thought about the privacy security and has done something about incident responses. I think if you're talking about intellectual property of the enterprise, your trade secrets, or physical assets, I think you're going to take steps to protect that. And I think you need to think of consumers' PII in a similar way. I actually have described PII as almost like some kind of caustic, toxic chemical that may be very useful in your business and may have high utility, but if you're not careful and it leaks out, it's going to cause some harm. We want to know what kind of training programs you had in place. Do you have adequate privacy policies? Are you implementing those privacy policies? With regard to cyber insurance, this has started to come up more. This is why I went to this cyber insurance conference last year. It's interesting, and from a regulator perspective, if the insurer acts as kind of a quasi-regulator in that it forces and challenges the enterprise to do these kinds of risks assessment, and they do it properly. But if it's just a Band-Aid approach where they just pay for coverage without doing the underlying assessment, it's not really going to be useful and kind of interesting to us. And also, just because you have insurance, to the extent that it can cover any penalties or restitution or other financial awards that we might seek, we may not stop it at the limits. So I'll turn it back to David.
So we've got just a few minutes for questions, so let's take care of them. We had a couple talking about lawyers and law firms in particular with some of their data protection needs and issues around attorney-client. And Adam, you mentioned that briefly, but Ollie, do you have anything to add?
Certainly. I think when it comes to law firms, on one level, just like every other organization, there are best practices that should be implemented from a people, process, technology perspective. That includes everything from encrypted laptops, and we all know how mobile the workforce is these days, through security training and having formal policies in place. On another level, law firms, of course, often touch very sensitive data, such as mergers and acquisitions or medical litigation, class actions. And in those cases, there could be additional steps that could be required. And I think it's worth remembering that the lawyer's professional policy that is typically in place would never cover all of the expenses that that we are talking about here. So I think particularly when it comes to things like the retention for the self-insured retention may be very different, and of course the types of exposure, particularly on the cost and expenses side, that would be covered under the any specific privacy policy versus an LPL policy.
Well, go ahead.
This is John. I was just going to add to that one interesting dimension to back up what Oliver was just talking about is a lot of firms do use cloud services for their customers' information, their clients' information, and that's one area where you really want to. We've talked earlier about vendors and outside parties. You really want to make sure you've got very strong provisions in your contract with cloud service providers to protect that information at all costs. Well,
you mentioned cost. We have law firms from around the country. Some are small firms. We even have solo practitioners, and we have a large, massive firms. What about the expense of data security for smaller groups, and also if you could comment about getting lawyers to actually do what they need to do to protect data, given they may be, stuck in old habits?
Maybe if I could take a first run at that. Certainly, I'd like to debunk one myth. Data protection and the measures we've been talking about don't automatically involve huge amounts of money. The first thing that can be done is on a simple procedural or protocol level, things like practicing good, what I call data hygiene, so deleting data that you don't need. Don't collect data that you don't need in the first place or you don't have a specific purpose for. And then also simple measures like effective use of passwords, effective software patching. And many of these things are free or almost free, and so don't always have to cost the earth.
Gotcha. I'm not sure how you'll be able to answer this one because it's kind of a tricky one, but a lot of the information that is preserved and is helpful certainly when you're trying to assess a breach and stop a breach, but when you get to, say, litigation, how much of that information then also becomes discoverable? How much should be put in formal reports? A loaded question, but does somebody want to take it? It's a good one, though.
Yeah, I think you should start from the position that anything that you're creating could potentially become discoverable. And I think utilizing the attorney-client privilege is really for the purposes of providing that legal advice and protecting the communication. And in the instance before litigation occurs, or there's an obligation to hold documents, you really do have the ability to protect the communications, but it's once litigation becomes reasonably likely and you begin to generate records and documentation that you really run the risk of having that becoming discoverable. So, I think it's something that you have to give some thought to in advance and have almost a plan around how these communications will roll and who within the organization needs to be aware of the facts as they're being developed, and whether reporting should or shouldn't occur in some instances, depending on what's discovered.
Okay. Thanks, David. We're going to take one more. Again, this deals with attorney-client. What are your thoughts on having a privacy officer as an attorney in your general counsel's office? Do you see risks to the attorney-client privilege?
John may have comments on this too, but I think that's certainly a valid concern to have, because I think it really depends on what hat that person's wearing. If they're a privacy officer and also reporting to the general counsel, it goes to the issue of, are they providing advice that's related to the business on privacy, or are they providing legal advice? And if it could be difficult to later go back and distinguish what advice was with which hat. So I think there is some concern. I mean, and it's the same sort of issue with a chief compliance officer that's also the general counsel. I mean, there has to be a lot of consideration given to what role that person's playing at any given point when they're creating documents or giving advice.
I think David really covered it. I would just maybe add a couple little factoids, which is a good majority of organizations do, maybe a third of them I've seen from reports, put their CPOs in somewhere in the reporting structure up to their general counsel. But as David said, I mean, that doesn't automatically insulate you within the attorney-client privilege. You really have to go and look at what is the advice that is being given, and privacy, data protection can often straddle the policy world or the legal world. You really have to parse it on a case-by-case.
Good. Well, thank you, guys. That is all we have time for. So I want to thank all of the presenters, Ollie with Liberty International, David with Nelson Mullins, John Kropp, a senior counsel, and Adam Miller with the California Attorney General's Office. Boy, I've never had that typo called out in front of so many people before, with the California Attorney General's Office. So thank you all, and on behalf of Lexis, I want to thank you, and thanks to everybody for joining. It was a great audience, and a very, very diverse crowd as well in terms of industry, regulators, and all sorts of law firms. Lexis really values the feedback on these programs, as do our presenters. So please follow the link to the survey. They take it very seriously in planning their next webinars and other content. So with that, I believe we are done. So we will conclude the webinar. Thank you all for attending.